addressing your lordships on today. The only way to provide succor to the needy is the affirmative action on which we will be addressing your lordships. What has come about to be, my lord, is not far to see, especially in our country, where the caste system, my lord, has prevailed for centuries, we are all aware, and there has always been a deep divide, and the ramifications of that have resulted, my lord, in certain castes being marginalized to a status of despair and almost of non-existence in the social fabric of our society. What has come to those who have been marginalized, in the generic sense of the word, we can call backwardness, because that word, my lord, will occur repeatedly as we address your lordships and refer to the judgments. In a generic sense, that word is backwardness, as opposed to what we never talk about and take it for granted for the people who have it, is forwardness. Forwardness is taken as an entitlement by those who have it, but what we need to really look at is the backwardness, and the backwardness, my lord, in my humble submission, can be faceted in many ways, it being social backwardness or economic backwardness or educational backwardness, so on and so forth, my lord. We can have a debate on this alone, that for those who suffer, what is the kind of ignominy and backwardness that they are victims of. But the issue, my lord, is the cure. We've been striving to find this cure through a series of judgments, through a series of legislations, through a series of executive decisions. But obviously, my lord, because we stand before your lordships to address again on this issue, means that much needs to be done. And what has been done is most certainly not enough. But if we were to put it very simply, though not a panacea for this ill of society, a cure definitely is equality. The only thing by which these lines can be blurred and we have a society that the Constitution envisages, the cure is eventual equality. Now, to achieve this, we must understand, however overrated the issue of reservation is, but reservation is only a tool. Reservation is only a means to achieve the end of the sacrosanct ideal, which is equality. Now, as in everything else, my lord, a tool is of no consequence till in the hands of a good sculptor. Merely providing for reservation is not the answer. A tool has to be used for the purpose that it has been designed to achieve the result that we seek to so desperately achieve for our country, which is equality. And this implementation can be done most certainly through law, definitely through the executive action of the state, and also through social debate. And the constitutional framers, Murad, had this intent very clear in their mind while providing for reservation. That the only reason which weighed with them was the realization of the disparity that existed, the disparity that was hard to ignore, the disparity which was in the face of the country when we became independent. And the effort was to achieve Bharat, India, where eventually everyone has a right to equality. So, Article 14 is what we strive to achieve, and everything else thereafter, in part 3 or the parts thereafter, has been designed to achieve that end, is equality of opportunity. It is not a case where we are before your lordships to say that somebody who has not played could definitely not have won. That's not the case here. The case here is, did he have a chance to play? Did he have the opportunity to play? Did he have the means to play? And did he even have the path to the ground where the game was played? The answer is no. When the privileged play the game and the top amongst them win, we fail to think about those who couldn't even make it to the playground because of the inadequacy of the means that they do not possess. So therefore, Mulad, I'll read the preamble, but what comes out of it is that equality of status and opportunity is the hallmark of our Constitution. And the assurance that we propose to give it is an assurance of dignity. Because no opportunity or status without dignity is complete. You cannot give opportunity as charity, because charity takes away the dignity. There have to be provisions enacted and implemented in law to achieve this equality of status and opportunity with dignity. And this is what can effectively eradicate what we call backwardness. Lord, there is a reason why, as I said, after 75 years of independence, we are still struggling to achieve this goal. It's easier written than implemented. The words have been there, intent has been there, the implementation has been there, but there is not much achievement to show for it, because what has been precipitated by centuries of suppression was not expected to go away in a decade. It wasn't. As some people might say, 10 years was the limit set for reservation to achieve what centuries had caused. Can't be done. We are very well aware of it, Mullah. But let us not marginalize the efforts that we've made, but most certainly we are not there as yet. And this matter, Mullah, is yet another effort to convince your lordships to lay down a law which will eventually help the benefits of reservation to percolate down to the strata who need it the most. Reason is, my lord, that a class of people belonging to varied castes, these are two different concepts, my lord. As we go along, we'll obviously dwell on them. That caste and class are totally two different concepts. A many number of castes in India, my lord, are stuck, unfortunately, in a self-deprecating cycle of occupational drudgery. Even today, there is one thing in inheritance which a lot of castes get, which is their occupation. Scavengers, sweepers, cobblers, blacksmiths, what they've handed down in inheritance, legacy, and estate to their next generation is an occupation which will never allow them to come out aided by what we call affirmative action. The reason is, Mullah, that there is a condition. We are all, as human beings, victims of conditioning. We are conditioned to believe that everything is all right. We are conditioned to believe that things are the way they are because they are meant to be. Oft heard dialogue is, my lord, if these people were not to do this job, who else will? And that is the reason these things should remain as it is, but that definitely is a mindset we need to shake ourselves out of. There are no ironclad barriers, my lord. It should keep the backward confined to their backwardness just because what they do is what nobody else would do, and their not doing what they are doing will not suit the entitled. That is the answer. We have to change these prejudices. We have to change the mindset The problem is the resistance. The problem is the resistance to change that mindset. The problem is that it seems like a huge shift in a societal mindset. Steer ourselves away from it and think that why can everybody in the society not be equal? And as we go along, the core issue here is not only the advantage and the disadvantage, but the more advantage and the more disadvantage within the disadvantaged. That is the issue that we are addressing, Your Lordships. Undoubtedly, my lord, the change has to come at the grassroots level of society. Undoubtedly. What happens in the mind is controlled by exposure, mostly to what is taught in each and every household of this country. That has to change. But it still does not take away the obligations upon the state to aid and assist this change, which either in the form of bringing about a law by the legislature, decisions of the executive, and more important than anything else, the laying down of the law by your lordships, which will eventually bring this change. Because once your lordships lay down a law, the acceptance of a proposition goes up tremendously. Because your lordship says so, there is a dispensation of the public to follow the law. So from either of these three wings, if an assistance and aid is coming in achieving these results, it is more important than the other. We cannot downplay any part of this. Because, as I put it, Muller, normally when we argue cases of reservation, a very common plea is raised that, my lord, I have 99% marks. I am being ousted by a person who has 56% marks. Is that fair? Yes, it is. It is fair because the person who has 56, he never had the means to be brought up in a family that you've come up in. He never had the means to go to a school that you went to the college that you went to, and to the competition preparation that you went through. And today, 99 is not your achievement, it is a conglomeration of all the factors that you've been through. That 56 is in spite of the factors that that child has been through. He has today reached 56 starting from zero. Your ride has been of an airplane from your birth. This person has walked his way to 56. That is what we need to understand. That the person who got 56 had no access to a dignified life. He was brought up in a neighborhood which did not give him any access to good education. What to talk of employment? And eventually, what are we striking to achieve here? By way of employment, we are wanting to make that person a part of governance. He has to feel that I am a part of running this country. I am a part of aiding the growth of this country by getting employment. That is why we'll mostly be, my Lord, on 16.4. So for that purpose, the obligation of the state is best discharged by affirmative action under 15.4 and 16.4 to give this person who is backward access. We have to give him at least an opportunity. I will go as far as to say, my Lord, that the old phrase that you can take a horse to water, you can't make him drink. We will have to make an effort to make that horse drink, because that horse has never seen water. That horse does not know that it is this water which will eventually quench his thirst for becoming a part of governance. He wants it, but he doesn't know how to get it, because he's stuck in a cycle of occupational drudgery, which the society doesn't let him come out of. Though opportunities are available, but they are not being capitalized because of, I would not say the intent, but the effectiveness of the implementation is lacking. Lord, eventually, if we all agree on this, that the goal is equality of opportunity, then what we urge before your lordships today is that measures need to be taken to make this goal not illusionary or formal, not a mere provision on paper. Simply, they have. And in this, there is a heavy onus upon the state, either at the center or the state level, for achieving this equality of opportunity. But this implementation has happened in phased manners. There have been amendments in the Constitution. There have been large number of executive orders, memorandums, laws, legislations brought out by various states. Lord, one of them of my state is under challenge before your lordships, from where this litigation arose. Just to put it briefly, though it's not a relevant, Lord, issue that your lordships would be deciding. In Punjab, Lord, we brought out an act in 2006, where out of the posts which were reserved for the scheduled castes, 50% of the posts were reserved for Balmikis and Mazhabis.
That was your first circular which you brought out.
Not this, yeah, no, this was not circular apart. This was the legislative act which was under challenge.
The circular preceded the
yes,
because the
yes.
circular had been struck down
That's
actually
right.
for want of legislative sanction.
So therefore, the legislation in 2006 and section 4, subsection 5, reserved 50% of the posts for Balmiki Sikhs and Mazhabis, and there is a twofold implementation which saves it from the vice of discrimination and reverse reservation and reverse discrimination as we know it. This reservation in the 2006 Act was done on a twofold check and balance. One, that this reservation was limited to 50%, which in the development of law has become the Lakshman Rekha, which we are all advised not to cross. And the second check and balance was that this was implemented on a preferential basis. So, my lord, as I would say, this was not an act of exclusion by any standard. By any standard, what Chennaiya, my lord, seeks to say is that this would be an act of exclusion. No. This was, if at all, an act of inclusion of those who were the most backward of the backward, to bring them, if not at par, at least up from where they stood.
Mr. Advocate General, when you said that it was implemented on a preferential basis,
That's right.
can you elaborate that? How was it implemented on a preferential basis?
Lord, so suppose there are 10 vacancies for scheduled caste in a particular year or a particular recruitment. 5 were reserved for Balmikis and Mazhabis.
Right.
If they were available. And if they were not available, it was to go to SC others, which are Ramdasiyas and other scheduled castes, which were available. So in every recruitment, one would ensure that 10 scheduled castes definitely came in. But at the first instance, the right of preference of 5 of those 10 was to go to Balmikis and Mazhabis.
So there was no carry forward for
Carry forward was blood and drop.
for the SC together.
Yes.
But not for the Balmikis and the Mazhabis within the SC.
They were exhausted within that recruitment.
Yes.
So therefore, if I can put it in cost-effective way, this preference-based reservation was not at anybody's cost. It was not that if they did not get it, nobody would get it. If they did not reach the Mulot cutoff for getting that reservation, a scheduled caste only would get it. And your lordships are right, those scheduled caste vacancies were to be then, in common law, as we all know it, to be carried forward and not counted towards reservation, this, that, and the other. All those parameters were to follow. It was not that they would either be converted to general or not be filled up and left vacant. There's nothing of that sort. So therefore, that is the core, blood, that if you cannot even as much as give preference to somebody who's really needy, without that being at the cost of somebody, and that act of the state government is squashed, is that correct? We are here to urge that before your lordship.
Actually, Mr. Advocate General, there is an element of exclusion. I mean, let's not gloss over it. The point only is this, that because, the same exclusion which applies to reservation per se,
of excluding merit, as we all put it.
Posts are reserved. Yes. Posts are reserved for a backward community, A. There is necessarily an exclusion of the forward communities in competing for those posts, right? Yet our constitutional jurisprudence permits it. Why? Because we treat equality as a substantive equality, not formal equality.
That's right.
Therefore, post N.M. Thomas, we have now developed jurisprudence to the effect that reservation is not really a breach of equality, but it
aid of equality.
But interestingly, the same argument which applies for reservation for the backward communities, the block, the backward versus forward, would also apply within the backward community, because what now we are really doing here by the measure which the Punjab legislature brought about was this, that within the reservation of seats for the scheduled castes, which is 15.5%, we'll take it for a moment, just as a benchmark.
That's right, as a ballpark.
Out of the 15.5%, which falls within the overall 50% cap, 50% of the 15.5% is reserved for the Mazhabi Sikhs and the Balmikis.
That's right.
Right? So, to that extent to which the reservation is exclusively carved out for them, the other backward castes cannot compete for those posts which are set apart from them. So, in a sense,
in the first instance,
in a sense, it is in that sense exclusionary. We can't gloss over the point that it is exclusionary.
We can't.
The only question really is this: can that exclusion not be justified on the same yardstick that we have applied for the exclusion in the backward versus forward context?
But if I had to put it very
Because within the backward,
Yes.
within the backward communities, within the scheduled castes, is there anything in constitutional jurisprudence which restrains the state from saying that I am not deleting a community from the list of scheduled castes which has been designated by the President in Article 341 or 342, but within those communities, I am now making a classification that certain communities are more backward and therefore in greater need for protection on the same touchstone of substantive equality. And if that can be done by the state in reserving in carving out certain posts out of the competition of the general community, then why can't the state do it within the backward communities? That's really the point.
absolutely.
But there is an element of exclusion, we must face it. I don't think we can gloss it.
What this entire example that your lordships have given is based upon a very simple word, which is relative backwardness. Once we concede to the argument of relativity and backwardness, and it is the backwardness vis-a-vis the forward which brings them into the 50%, and it is the furthermore backwardness within the 50% which gives them the reservation within the reserve, then this argument has no problem.
Now, Chinnaya's whole rationale was this, that the power to designate communities as scheduled castes and scheduled tribes exclusively belongs to the president and now therefore parliament. For instance, in Milan, we have got all those Palghat Jila Thandan, Milan Katwari, which came from Maharashtra.
That's true.
It is not open, for instance, for the court to say that though this community is designated as a scheduled caste, another community is part of the designated community. You have to take the list. You can't do that. What is that jurisprudence is now very, very well set.
That power has been reserved.
Try and think of the list.
That power has been reserved for the parliament, remains so.
That's right. But the argument that seems to have found favor in Chennai was this, that if that is so, then the state cannot classify within the list of communities which are designated as scheduled castes, because to make that classification would amount to an exclusion of some communities within the scheduled caste. That seems to be the logic.
Yes and no.
Yeah, I mean, very simply put, that's really the heart of the controversy.
Because Chennai, in my humble submission, was a plane which took off from the wrong runway.
And your argument would be, I guess, that